panel that we have managed to assemble is, I believe, a very diverse experience. We have Mr. Dinesh Bareja, one of the senior most security experts in the country. We have Mr. Rahul from the policy making side. We have Mr. Kamaneesh, Honorable Judge, NIA cases, Kochi. We have Dr. Swapnil from the academician side. The topic that has been put forward is power of control navigating the PDP Act. As a majority of us here, I believe, are from the tech industry, and we are all concerned with data, either collecting, accumulating, transferring, or using data to provide services, etc. So it was a concern among the industry as to when we could get a dedicated digital privacy regulation for India. Although the process began in 2017 with the Justice B.N. Sri Krishna Commission, framing up the structure of the proposed legislation. But then from 2017, we traveled to 2023, and it's only by August 4th that we could manage to have an act passed by Parliament and the assent given by the President. However, just to enlighten people here, of course, most of you must be aware, although the act is in place, it has not come into force as yet. The Government of India has, through the voice of the Honorable Minister, stated that the act should be brought into force within 10 months. And it's also available in the public domain that the rules are also being formulated, and it should be out in 30 days. This is what I understand. We are all hopeful that from a space where we had only one provision under Section 43 capital A of the IT Act, which used to take care of the so-called data privacy or data protection realm. Finally, we have a proper enactment, which is the Digital Personal Data Protection Act 2023. I welcome all the panelists, first of all, and I am very hopeful that their insights on various serious issues should enlighten all of us. So with all of your permission, we'll just start the discussion. A warm welcome, everybody. First come first, we start with the Honorable Judge. Being on the bench as a judge, I personally believe that you would have seen a shift and a change in the landscape of how data is defined, data is understood, and how seriously data is taken. Now, having said that, as a perspective from a judge, could you enlighten us what could be the most significant challenges and concerns that the individual and organizations could face while complying the act? Of course, bearing in mind it has not been brought into force, but we all believe that there might not be very grave changes to it. So just keeping that in mind, if you could kindly enlighten us. Please.
Thank you very much, Prem. And well, that's a very complicated question, I must say. First thing, this brings up certain new conceptual ideas. First thing, so in the Indian law, there has not been any statutes covering this particular topic like data protection. Of late, we are not a community who is rather acquainted with this concept as data as a movable property. Data has never been considered virtually as a movable property till recent years, but we have changed a lot. We have changed a lot, surfing by the enormous sort of judicial precedents that we come across day by day. we understand that this particular concept is being understood. But here we have very, very crucial difference. Under this particular statute, there are two concepts like the data principle as well as the data fiduciary. So basically, if I own a data and that over which I can identify myself or some other person can identify myself, this is exactly my property. And if I entrust this data to some person for some definite purpose, that definite purpose should be his Lakshman Rekha. And he should not cross it, transgress it. This is a new idea that is being told by this particular piece of legislation, of which I do have my own reservations. Obviously, my own reservations, because many concepts which we rather have in mind has not been is not finding a place in the particular statute. That we must see. First thing, shall I speak you about my reservations as well? How much time do I have? Fine. I'll take only 5 to 7 minutes. So fine. First thing, this personal data. The definition of this very personal data is a reservation. It's a point wherein a major reservation, or rather a major challenge we are going to face. It means data about an individual who is identifiable by or in relation to such data. Maybe it has been taken from the British Act, the UK Data Protection Act of 2018, wherein it is slightly different. But the problem is that, see, as per the new legislation, there is a very general definition of this data privacy. I mean, this data protection, personal data. How come personal data is being analyzed? Well, I will always agree that this is a very general term. If I happen to move to some particular location, and whether my location is a personal data, this question is there. So it could have been somewhat inclusive. It could have been somewhat inclusive. Of course, there has to be deliberations over it. And then, I have noted many, but I will not be focusing more on it. Well, there is one exception that is there under section 3C. Exactly 3C, probably 2. Personal data that is made or caused to be made publicly available. See, there is a conceptual issue there. If I happen to publish my own photograph in a social media account, say for example Instagram, X, or Facebook, or anything else, do I offer to the public, the public at large, that my data is up to you, is available? It's not like that. Maybe I am publishing it in a Facebook group. How can you understand it? So these questions are there. It has clearly, in an exception, it has clearly tagged out these persons who have made their data public. So once we make some publication about some data, see, exceptionally, data becomes private personal data in certain circumstances and certain exigencies only, which you cannot foresee. So this issue is there. They have given a very speaking example of it. I actually have this reservation about that thing also. Well, there is one more aspect. There is one more aspect which I need to speak about. There is one provision, section 7B, wherein state is being exempted. Well, what it says is that the state and any of its instrumentalities. It's very debatable. Instrumentality has never been defined anywhere, neither in this particular act, nor in the General Clauses Act, nor anywhere. To my knowledge, anywhere. I'll stand corrected if I'm wrong. So this aspect is there. If you happen to see, I will visualize a time. Well, BSNL or some other state-owned company, wherein 51% of the stock is held by the government. It's a government company. Whether a government company is a government instrumentality which can claim exemption from data protection, this is another issue. And BSNL is issuing a permit to somebody. Can it claim this data exemption from, absolute exemption from, blanket exemption from this data protection? This is another issue. Well, and there are anything that under section 10(8)(10)(a), a data fiduciary shall establish an effective mechanism to redress the grievance. There is it, an effective mechanism. What sort of effective mechanism? How effective it is? In what manner you call it effective? These are not there even in the rule-making scenario. This aspect you have to see. Then there is something which most of the people will be very much interested. There is a provision for appointment of an independent data auditor for a what is it, dignified, I mean, what they call it? Significant data fiduciary. There are certain institutions, there are certain institutions wherein they have given clear parameters to understand which one will be a significant data fiduciary. So here is it. Here is it. Who is that? What is his qualification? We are in the dark.
I can pause for a minute.
Sure.
That was a perfect opening to understand what are the loops and the holes in the present enactment. Well, shifting from there, I'd come to you, Dr. Swapnil. From an academician's point, of course, all of us were eagerly awaiting the enactment. Now, since we have it, we have a chance to debate on it. So from the academician's view, could you provide us a brief overview of the fundamental concept and principles of the Act? And when compared to the international precedents, please.
Thank you, sir. Now, with respect to the Act itself, as we have said that the Act is not in force yet. What comes to my mind is, there were three monkeys story of Gandhiji. It says that, Bura mat suno, bura mat dekho, bura mat bolo. The same way the concept has changed. Bura mat type karo, bura mat like karo, and bura mat share karo. Right? Now, exactly on that same count, the government wants to take care of multiple things. But see, when you are doing these kind of things, like, trying to regulate these kind of things, it's naturally going to be a big challenge. Now, no doubt, we had a provision in the form of 43 capital A in the original Information Technology Act, which is like now undone. Now, we don't need it. And because we have a comprehensive law coming in now. Now, the biggest challenge what we have is that how exactly are we looking at it? See, to be very honest, from an academic perspective, what I can say is that we just had two options. One is to either follow the US model, where they're just, putting a commission like Federal Trade Commission or something like that, and then just, bring every single communication under the, wraps of it. Or there was another model, which is basically, as I call it, like, typically EU model or European model, like what they do in respect of GDPR, the General Data Protection Regulation, as they call it. Actually, our data protection in academic way, I see it very close to the GDPR one. Now, when we say that it is very close to GDPR one, there are few things that we need to understand. It's very easy for us to just compare and say that we are just associated with the GDPR angle. But GDPR has its own flavor, it has its own way of applicability. Are we able to grasp that in terms of our own conceptualization in India? Well, anyways, Indians are known for that. We put a tadka to Chinese in our own way. Like, the flavor is Indian flavor to Chinese. I can guarantee you that the Chinese will never have that kind of a spice in his life. So we can spice up anything and everything for that matter. Now, when it comes to spicing up of this subject matter, you see, 2 points sir has already mentioned. One thing which I conceptually feel is very vague is basically what they call it is like, sufficiently, you have to look at the data processing units. How are we going to see it beyond principle? How exactly are we going to go do it? Now, one thing what we need to understand over here is that when I look at the data, now you see, are you applying it to the entire data, entire personal data? That needs to be monitored, because I still have some doubts with respect to what exactly are we saying. Because as far as exemption clause is concerned, like sir has already mentioned, government or law enforcement agencies would be there. But even more than that, what they have stated is that something which is already in the public knowledge, that again cannot come under this. It is an exemption. Now, for me, it is a matter of a little bit of a hurdle to understand that, how exactly conceptually I would read it, that, something is
I'd just like to add into this.
Yeah.
Since the depth of the topic goes to definition of data.
Data.
Data as defined in the IT Act is still prevalent.
Yeah.
It
Yeah.
has a more exhaustive definition than what comes into the
DPDP Act, yeah.
So interestingly, IT Act has a more comprehensive definition than
Than the DPDP, correct.
please.
Now,
Now you
now
can.
that's where it is that, first is this hurdle that we have. Secondly, that what do we mean by publicly available data? Now, there is a big question mark in relation to that. Where it says that it is an exemption, that it is a publicly available data that is exempted from DPDP. Now, come on, I mean, if somebody, like just a wild scenario, a wild guess, somebody has hacked my system, put up some data about me on a social media, can I simply say that it is a publicly available data? Was it with my consent? Second, there is a technical know-how that we need to understand. It's associated with right to consent. Now, the law talks about, the DPDP bill talks about very heavily with respect to the consent of the principal. Now, I have a little bit of hitch in seeing that. You see, they say withdrawal of consent is the power of the principal. So it's my data, I have the right to withdraw. Now, tell me how exactly you are going to monitor that. It's technically sometimes difficult on certain platforms to, just withdraw it and just to put it across.
More than withdrawing and the provision to withdraw, when can I withdraw?
I mean,
At what moment can I withdraw?
exactly. And then how to monitor it? Like, my consent is okay, fine. Then you would add every single place, there would be a button, there would be I agree, I accept, I don't consent, I consent. But after a point of time, the mechanical process would lead on to another set of burden. What I see is that, okay, fine, we have, we had a big shift in terms of our jobs or our creations. It would even change even further when I see this. So
Exactly.
definitely, conceptually, there would be many, many challenges that would be coming in. That's
Thank
for
you so
sure.
much. So we have widened out the perspective that we are discussing. I'll now reach out to Rahul ji. As a policymaker or a person who follows policy making very closely, I would just request you to just align us as to how does the Act align or differ from the international data protection trends or practices, bearing in mind which I think Dr. Swapnil has already opened up. So your views, please.
Thank you. So first of all, thank you, Manoj sir and c0c0n for the opportunity. I think if you look at the trajectory which the direction has taken, like the data protection journey, like you mentioned about the Aadhaar case and Justice Sri Krishna committee, but I think the process started in 2008 where there was an attempt to formulate a right to privacy bill, which later translated in 2012 into Justice AP Shah committee. And then there was a draft bill prepared by DOPT in 2014, but then government changed and the entire effort went through. And then yes, after 2017, we had seen a steady momentum, multiple versions of the bill, and there have been drastic changes in the positioning the government has taken. It's very difficult to understand why there are 180-degree U-turns on lot many subjects without any clear explanation on why we are approaching this one way or the other. Right. But like there has to be, I'm just trying to align a lot of changes which are happening post-COVID with the larger geopolitical realities, because I think those trends have to be taken into consideration because they follow a particular pattern on how nations and policy making happens, especially on these important matters. Data protection bill is one of the most important bills that have been passed in I would say many decades, because the impact it's going to have is huge. And therefore, why did the government, which was pretty heavy on data sovereignty and localization, suddenly take a very softened approach and no questions asked and bill is through? But if you look at like the larger changes which are happening post-COVID and conflicts and migrant crisis, supply chains, etc. So these data processing as an subject and domain of its own has gained a lot of importance for the countries. This has become as an instrument of not just negotiations, but as an instrument of uh, laying out your, like wielding your power in certain way. And hence, because of the slowing of economy, the countries thought that rather than trying to close up the borders with the data and divide into multiple spheres with localization, with a trend to follow, it's going to be very difficult. So let's attempt to integrate. And surprisingly, after the Indian approach, when the DPDP got passed this time, very recently, I think just 8 days back, even the China has toned
Yes.
down its
Is opened up a
data
bit.
transfers
Opened up.
quite significantly.
Yes.
Because I think these larger trends are driving uh, growth against security consideration, especially the global south. I think that we have to keep in mind.
Sure, sure.
Do you want me to talk about specific changes?
If I could just get in,
Yes.
Mr. Dinesh also, who's been listening to us very patiently for the last 20 minutes plus.
No, I'm absorbing a lot of gyan over here. Yeah.
Dinesh ji, being a person who's been in the industry for so long, how do you see the Act impact cybersecurity practices within organizations and in industry you belong to? Your views, please.
Give me a minute.
Please, please. Can someone let me know
Impact-
how much time we have left? $10. Fine.
So impact on an organization, let's say, now I'm coming to the organization perspective, is going to be huge. There's already, I would say sort of a tsunami which has hit the industry, which has hit practically all the industries. And my I would say, take is that the tsunami is only because of one reason, 250 crores. Nothing else. There's no driver. Nobody cares about the act. Nobody cares about the human being. Nobody cares about anybody's privacy. They're only worried about 250 crores. And a couple of large companies which I'm associated with, they only want to know क्यों होगा, कैसे बच सकते हैं, what do we need to put in place. See, these companies, unfortunately, don't even have a data classification. They don't even know what private information they have. Okay? So they have a huge challenge. Imagine a company which has got, say, 100,000 employees. Or forget 100,000, talk about 1,000 employees. And they've been running for the last 15, 20 years. That means there's data which is being churned. People have come in, joined and left. Now that data needs to be cleaned up. They don't even know where it is. So how are they going to maintain the new data? They're only worried about 250 crores. And that's the board is talking about that, right? The points which you have mentioned right now, I just have a couple of comments on that too,
Yes, please.
okay? The definition of personal data, forget it.
Yes.
The personal data to be, what is to be made public? No. FTC or GDPR, that is what they're concerned with because it's 5%. GDPR charges would put up a 5% this thing. But people are running or were running behind GDPR, even though it was not applicable to them.
Right.
If you remember the first few years, that was one tsunami, and everybody was scared. You are not managing any EU data.
Right.
Why are you worried about that? Okay.
Yeah.
And how will you withdraw consent and confirm? So right now, the 250 crores has driven another action in among these companies to settle to make a DPO. And shamefully,
Right.
a CISO or a CIO or a CA or a CISO is redesignated as a DPO.
DPO.
So you have CISO and DPO, this and DPO. Now where the DPOs come from? Today, if you say you become a DPO, I have not done a security implementation. How will I be a DPO? I'm a security guy. But no, DPO bana do. Chahiye. There are no rules framed. There's a board which is still to come in. We only have an act.
Yes.
We have an act.
Exactly.
Based on this, people are scared. They are so badly scared. Anybody is being made a DPO, and I don't know whether that CISO gets a DPO designation. and a salary hike or not, but that's a different story altogether.
Of course.
Eh? No, and one more point.
Yes, please.
And like he mentioned about the history, I just want to talk about the history. I've seen it from Sri Krishna, and I have had an argument with him also. My take at that time was that this is not happening. I've always maintained this the privacy bill will not come, and I've done it in public and private. And he had a fight with me also on that. Aayega, aayega. I said, nahi aayega. Eventually, the Sri Krishna thing was, shelved. Fine. I still said nahi aayega. The reason is very simple. Why has that data sovereignty been softened down? The lobbies are too strong, sir. There are undercurrents which are too strong. All of us know what are the undercurrents. All of us know them. And the Sri Krishna Commission, PDPB, two factors over there were worth looking at. One of the signatories went in opposition a week after it was made public. One of the signatories to that. Why did you sign it? Okay. Then IAPP, the supposed gold standard of the world, they put out a paper, PDPB Act. I put out a thing, I said, how do you say it is Act? No, it has been put, it has not been promulgated, there's nothing over here, it's still a bill.
Right.
Anyway, to you.
So the industry perspective is what I believe from Dinesh ji is a lot of scare and a lot of uncertainty as to how compliance, etc., can be put in place. Quickly wrapping up in the final rounds of it, we are running short of time, I believe. Over to you, Kamaneesh ji. Well, with all those aspects still lurking on what we have discussed, is not a topic that can finish in the time slot which we are heading into. But at least to open up and give some tinkering to all of us here from the aspects of all the professionals here. Now, as a judge, if I could ask you to quickly let us know, what could you see the role of a judiciary in interpreting and adapting to this act?
Yeah.
A quick wrap up.
Thank you very much for that question, very intelligent question. Rather confusing as well. It has two institutions defined in the Act itself. One is the board and the other is appellate tribunal. Well, there is one more folly. Should I call it? Should I be that crude in using my terminology? Is another question. Well, there is one thing is there. The board passes orders. All these are penalties. See, this is the way it is done. All these are penalties, and it has not been given the status of a court decree. Fine. But the appellate tribunal, you take from the orders, you take things in appeal, and there the appellate tribunal passes an order that has got the status of a decree. For what purpose, I just do not understand. Well, the board seemingly does not have a power to grant you any personal compensation. Do you agree? I do not know. You must have gone it. I didn't see such a provision. No, it doesn't have such a provision. So actually, to designate it as a court decree is rather of no use, practically of no use. Well, Section 34, you go into Section 34 and there you find that the entire penalties go to the consolidated funds of the union. So it is very clear. Whatever amount that you gather from the law breaking is up to the consolidated funds. You are not going to get anything. So there is my question. One question is there.
Right.
Do you mean to say that the civil court's jurisdiction, the regular civil court's jurisdiction in case of breach of personal data
Yes, sir.
is protected or not? Is
Right.
still there or not?
Right.
Has it been taken away?
Right.
My stand is that it has not been taken away because for something that existed, a new institution is coming under a particular statute. And that statute does not provide for personal compensation. And if you sue somebody for breach of your own personal data, I think the civil court's jurisdiction is not ousted, and this will be the greatest challenges that the judiciary is going to face with this act.
Yes, sir. I'm constrained.
Well, we had been finding fault throughout. The judges are known for that, probably. You excuse me, judges are known for that. But one thing very positive, I must say. The universal gender has not been used in this particular
I agree.
statute.
I agree.
Instead of he, it is she.
Yes, I agree.
Maybe Harari's legacy.
Right. I'm constrained. I've been just told that we need to wrap up. So I don't think we might have a second round to go. So my apologies to all the panelists for that. We are running short of time. But if I can take a quick takeaway, well, we have concerns about consent. We have concerns about definition of data. We have concerns about compliance of the industry, which way to structure it. And we also have concerns about the jurisdiction, how it's going to be framed. So as of now, I think we can have a quick takeaway that we can be happy that we have something by the name of the Digital Personal Data Protection Act. Well, it's a step forward for sure. And I think we all should appreciate that. And as usual, the law needs time to mature. When the law is brought into force, it takes time to mature.
Yeah.
So I think we can wrap up with this, that we hope that the structures which are being formulated by the government will be giving teeth and will come to use of the purpose for which the enactment has been brought in. Thank you everyone for bearing with us. Thank you the panelists. Thank you so much. Have a good evening.
CERT India says PII and SPDI, and nothing is mentioned in this act.
Duly noted.
So London, so one side is going to London, the other is going to Tokyo.
Okay. Very graceful of her. Any questions from the crowd, please? Feel free.
Thank you very much, panelists, for that insightful session. So I got two questions over here. Number one, say if I submit my Aadhaar card Xerox to someone, if those Xerox papers have been lost, will this be come under this new act? And number two, if the data is lost, will there be any compensation given to the data subject?
Your question is to whom in the panel?
Anyone can answer.
Anybody in the panel who can take it, please?
Sir, just a quick this thing, like, you said Aadhaar card. We have just one small example that we had prior to Puttaswamy case. Prior to Puttaswamy case, if I remember it correctly, only the state of MP, a person had said that we need to understand, because, earlier there was this 43 capital A as a provision, which said that any body corporate. So the person just simply asked the question before the High Court that, sir, is UID a body corporate? And interestingly, the answer was negative, that it is not a body corporate. So now you cannot claim anything against UID. And that became a trend in majority of the states. So it is difficult to digest that, but yes, definitely the thing has been rectified due to Puttaswamy's decision. So for me, I would be like, see, a typical Indian approach towards this, if I keep it, I'm happy to share my data with a government official rather than a private entity or a foreigner. That's where it exactly ends. There are two sides of your question. I understand this. This would be my academic perspective. I think from judicial perspective, there will be something else added with this.
Nothing more to add from the functional area, but I will point out, I will tell you to wait till the rules are framed.
Exactly.
I'll tell you to wait till the rules are framed. Things are, it's unclear. I must confess that it is unclear. But anyway, DPDP Act is one step forward.
Yes.
We need to have this legislation.
Yes.
To what extent they will be, which provisions they will be, putting into operation for the time being, we are not sure about. It's for the policy makers. But this is definitely one step forward. We may have to wait till the rules are framed, I think. Personally, I don't find any provision wherein you will get compensation from the board or from the appellate tribunal, personal compensation on a personal note. You may not be getting. Penalties will be there, but there may be provisions in the rule, while the rule making is there, which authorizes the board to award you personal compensation from out of the penalty, right? This provision is there, but it is still unclear.
I hope that clarifies.
Yeah, so my first question was on a different note. So we give
I
our
think, I think if you could, we can come down and we can speak to you personally. I don't want the track to be delayed because of it. We'll come down and we'll specifically speak to you. If you could just give me 2 minutes. Anybody else with the questions? Well, fine. Thank you so much. Thank you so much.